State, we have been instructed by our client, Mahadi Energy Ltd, and Mahadi Energy Ltd owns one of the top 5 biggest inland container depots in this country. And the background is that Mahadi had taken some loan facility from what was then called First Community Bank, amounting to over 630 million Kenya shillings. Over due time, rather in the course of time, Mahadi claims to have already paid off that loan, given that it was a loan that was advanced in terms and in line with the Sharia laws that govern Islamic banking and finance. Now, these laws are very particular to the way the issue of interest and other charges are handled, given that the principles underlying Islamic banking and finance is that money is not and should not have an intrinsic value, but as a means of exchanging goods and services. Now, Mahadi, or rather First Community Bank as it then was, which was then later acquired by Premier Bank, went and obtained auctioneers and auctioned the properties belonging to Mahadi. And we even have reports that some of these properties which were auctioned were not charged over the initial loan. Now, after that, Mahadi then went and moved court, filed an application dated the 18th of October 2024 in Mombasa, and Honorable Justice Olga Seven issued conservatory orders, given that it was in the form of a petition, stopping the auctioneers and everyone who had claimed to have bought that property and all those properties that had initially allegedly been charged from entering and dealing with those properties. Later on, those orders were then reaffirmed on the 25th of October 2025 by Honorable Justice Mutai. And unfortunately, as we have been seeing as a crop of practicing and what we can deem as illegal practice, the people who bought these properties and who have identified themselves as Shabeel moved the ELC court here in Nairobi and obtained orders evicting Mahadi Energy Ltd from the properties they allegedly bought from that auction. We then moved court with an application which we filed on Friday the 24th, and in it we are arguing that the orders which they obtained and were given by Honorable Justice Kulo of the Environment and Land Court here in Nairobi were improper and illegal on the basis that they were obtained when, or rather, having had an issue of material non-disclosure. Because the non-disclosure in this point points out to they did not disclose the fact that there was existing orders from Mombasa by the by the ruling of Honorable Justice Gregory Mutai, stopping and barring the interference of those properties. But here again, we can see they moved the court in the ELC and obtained what we can now call arbitrary orders, which are now evicting our clients from what has been termed as an illegal acquisition of their properties. And we say illegal not so loosely, but as a matter of fact, given that even at the time of obtaining these auctioneering orders, the debt that was allegedly owed to Premier Bank was not established and has no equal footing to warrant the orders that they received. Therefore, our application has been given directions to be heard today on an urgent basis, and we are awaiting the directions of the court, and the file has been actioned to Honorable Justice Mohammed Uno.
Of utmost importance is to understand why this is a national issue. Mahadi is the third largest internal depot, container depot in this country. It is served by more than 15 shipping lines. All the ships from China, India, Pakistan, Netherlands, Denmark, Britain, USA, South Africa, Norway, dock and put the containers at Mahadi. These containers are for countries within the region, that is Tanzania, Uganda, Rwanda, Burundi, Mozambique, Botswana, Southern Sudan, Ethiopia, Djibouti. All these countries have no supplies. That's the first issue, that this order has made other countries within the region to suffocate because they cannot be able to get supplies. Number two, the containers that have been locked in and the materials are worth more than 14 billion Kenya shillings. That is the property that has been kept. Some of the containers have perishables. Some of the containers are carrying critical supplies to neighboring countries. Also, the containers that are empty are supposed to be taken out of the country for them to be loaded and brought back. Third, the revenue the country is losing. The port, inland port, is employing the tune of around 400 to 500 Kenyans who now are jobless. The KRA collects millions on monthly basis from this area. The young people who are working there are now not having any gainful employment, and families multiply effect. We are dealing with around 2,000 families that are going to be affected. Third issue is that this has never happened. A case filed in Mombasa High Court. People leave Mombasa High Court, pass Kwale, pass Malindi, pass Voi, pass Machakos, pass Kajiado, come to Milimani. A judge in Milimani is equal to a judge in Mombasa. So there is no way a judge in Nairobi can review or sit as an appellate court against another judge in Mombasa. We have checked. They never told the judge in Nairobi that there were matters in Mombasa. The subject matter is a port in Mombasa. It's not a port in Nairobi. So territorial jurisdiction vests in Mombasa. We have brought this to the attention of the judge. We expect that will be heard today at around 2:30 so that those orders can be vacated to allow the port to run. Otherwise, we are now facing a major maritime crisis where the port of Mombasa is going to be downgraded because the congestion that is going to accrue out of this will affect our neighbors. And that is why we have come to put to the world that this is a national security issue. We shall be moving internally, administratively, to raise the relevant arms of government to ensure that this is sorted out so that Mombasa Port does not clog and we have neighbors moving to Dar es Salaam, neighbors move to Kismayu or move to other ports around the Indian coastline. Thank you for that.